लाइव हो रही है
Thank you very much. May I seek the permission and good wishes from the Honourable Chair to commence the proceedings of the day. May I, Honourable Sir? Thank you very much, sir. May I request that Honourable Mr. Justice Sanjay Kishan Kaul, sir, Judge Supreme Court of India, and Executive Chairman Nal, sir. Honourable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India. Honourable Mr. Justice Manindra Mohan Srivastav, sir, the Acting Chief Justice of Rajasthan High Court and Executive Chairman RSLSA. Honorable Mr. Justice Vijay Vishnoi, sir, Judge Rajasthan High Court Jodhpur and Chairman Rajasthan High Court Legal Services Committee Jodhpur. Honorable Mr. Justice Pankaj Bhandari, sir, Judge Rajasthan High Court Jaipur Bench Jaipur and Chairman Rajasthan High Court Legal Services Committee Jaipur. Honorable Consultative Committee Nalsa, Honorable Executive Chairman SLSAs, Honorable Chairman HCLHCs of Madhya Pradesh, Gujarat, Maharashtra, Chhattisgarh, Dadar and Nagar Haveli, Daman and Diu, and Goa. Respected members, secretaries, SLSAs, distinguished guests, print and media electronic personnel, ladies and gentlemen, I welcome you all to the West Zone Regional Conference on Enhancing Access to Justice, held under the aegis of National Legal Services Authority NALSA in Udaipur, Rajasthan. I welcome you all to the city known as City of Lakes or the Venice of East. May I now request the guest dignitaries to please come on the dais, sir. Thank you very much, sir. I welcome you all to the city known as the City of Lakes or the Venice of East. But honorable guests, dignitaries, ladies and gentlemen, Udaipur is known not only for its splendid lakes and picturesque Aravalli ranges that are majestic and have been guarding the country since generations. It's also the city of valor, sacrifice, traditions and culture. Rajasthan has a distinguished way of welcoming its guests. Here we say, Khamagani, or we say, Padharu Mare Des. So I once again welcome you all. I welcome you, sir. May I now request honorable dignitaries on the dais to light a diya as a mark of respect towards Goddess Saraswati, the goddess Ma known as the goddess of knowledge, music, art, wisdom and learning. Lamp also signifies the light around us. It's a synonym of freedom from the ignorance. It makes us to believe in sacrifice for the greater cause. It beckons human mankind to spread knowledge in the world. And that symbolizes the awakening of innate wisdom that lies in all of us.
Sir, please come. Thank you.
Thank you very much, sir.
Yeah.
Now next we move ahead and we start with the felicitations. May I request Honorable Mr. Justice A.J. Desai, Acting Chief Justice Gujarat High Court and Executive Chairman Gujarat SLSA, to felicitate our Chief Guest Mr. Honorable Judge Sanjay Kishan Kaul sir, Judge Supreme Court of India and Chairman Nalsa, by presenting a live shawl, presenting a live plant and a shawl. A plant represents life, growth and progression, and this is what we pray for our guests who have arrived today. Presenting a shawl symbolizes respect and gratitude for our guests. Thank you, Mr. Justice Desai. I request Honorable Mr. Justice Sheel Nagu, Executive Chairman, MP SLSA, to felicitate Mr. Justice Sanjeev Khanna, Honorable Judge, Supreme Court of India, with a live plant and a shawl.
Sir, look at this. Thank you.
Thank you, Mr. Justice Nagu. Now I request Honorable Mr. Justice R.D. Dhanokar, Executive Chairman, Maharashtra SLSA, to felicitate Mr. Justice M.N. Srivastava, Honorable Acting Chief Justice, Rajasthan High Court and Executive Chairman, Rajasthan State Legal Services Authority, with a live plant and a shawl.
Sir, look at please. Thank you.
Thank you, Mr. Justice Dhanokar. May I request Mr. Justice Atul S. Chandorkar, Honorable Judge, Bombay High Court and Chairman, HCLHC Nagpur, to felicitate Mr. Justice Vijay Vishnoi, Honorable Judge and Chairman, HCLHC Jodhpur, with a live plant and a shawl. Thank you, Mr. Justice Chandorkar. May I now request Mr. Justice Sanjay S. Agarwal, Honorable Judge, Chhattisgarh High Court and Chairman, HCLHC, to felicitate Mr. Justice Pankaj Bhandari, Honorable Judge, Rajasthan High Court and Chairman, HCLHC Jaipur, by presenting a live plant and a shawl. I am so sorry, sir. I really apologize for the mistake. May I now request you to do the honors?
Sir, look at please. Sir, please.
Thank you very much, sir. Thank you very much, sir. I think it's all my mistake. I apologize for it. I have never seen such a big galaxy of, the guardians of legal fraternity. So I may be a bit nervous about it. I really apologize, sir. Thank you very much. The National Legal Services Authority, NALSA, has been constituted under the Legal Services Act 1987 to provide free legal services to the weaker sections of the society. It ensures that opportunities for securing justice are not denied to any citizen by the reason of economic or other disabilities, and to organize, it also organizes Lok Adalats for amicable settlement of disputes. May I now request
एहसास आकाश न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए। अपने इस हिंदुस्तान पर हक हमारा भी तो है, इंसान एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
ये ना सोचो दर्द हमारा कहीं सुना न जाएगा, अब न्यायालय खुद चलकर चौपालों तक आएगा।
लाचारों को न्याय मिलेगा, दुखियारों को न्याय मिलेगा, कमजोरों को न्याय मिलेगा, मजलूमों को न्याय मिलेगा। अपने इस हिंदुस्तान पर हक हमारा भी तो है, उम्मीदों के इस गुलसितां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
गरीब और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा, न्याय सबके लिए।
Services Authorities and Chairman, High Court Legal Services Committees of the State of Chhattisgarh, Dadra and Nagar Haveli, Daman and Diu, Goa, Gujarat, Madhya Pradesh, Maharashtra and Rajasthan. Honorable members of the Advisory cum Consultative Panel of NALSA, brothers and sisters, Member Secretary NALSA and Member Secretaries of Chhattisgarh, Dadra and Nagar Haveli, Daman and Diu, Gujarat, Madhya Pradesh, Maharashtra and Rajasthan Legal Services Authorities. My dear judicial officers and other distinguished guests, ladies and gentlemen, a warm good morning to all. It gives me immense pleasure to welcome you all to this magnificent lake of city for the West Zone Regional Conference of Enhancing Access to Justice. It is a proud moment for the entire Rajasthan judiciary that we have received this great opportunity to host this regional conference. I, on behalf of Rajasthan State Legal Services Authority, heartily welcome you all. West Zone Regional Conference is organized under the aegis of National Legal Services Authority to deliberate upon relevant issues relating to providing legal services and spreading legal awareness. This conference also provides an opportunity for all the states facing similar circumstances to come together and evaluate the implementation of legal aid schemes and programs. It is indeed heartening to welcome in our midst Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairman NALSA, whose standing as a beacon of judicial wisdom and acumen is legendary amongst the legal fraternity. His Lordship has brought great encouragement to the legal services institutions across India. His Lordships, by untiring and relentless efforts, devotion and dedication, has steered NALSA and along with it all legal services institutions of India towards the ultimate objective of 100% legal literacy and through a process of reform in order to ensure access to justice to every man, woman and child. We are immensely thankful to His Lordship. Welcome to Honorable His Lordship's kind and generous presence and vision regarding enhancement. Also gracing us with beaming presence of Honorable Justice M.M. Srivastava, the Acting Chief Justice, Rajasthan High Court and Patron-in-Chief of RSLSA. His Lordship is the true embodiment of all the pious and judicious in the legal Indian judicial system. It is under His Lordship's able guidance in Rajasthan that Rajasthan has disposed of more than 76,19,904 cases in National Lok Adalat since March 2022. We are indeed privileged to receive continuous guidance and support from His Lordships. It also gives me great pleasure to have my brother Justice Pankaj Bhandari here with us, under whose mentorship Rajasthan High Court Legal Services Committee Jaipur is scaling new heights. I am humbled to receive the opportunity of welcoming my brother and sister judges from various high courts of West Zone. It is not long ago that when we met in Jaipur for the 18th All India Legal Services Authorities meet, which gave us opportunity to fraternize with each other. I am hopeful that this conference will not only give us another opportunity to bond, but also to establish a new paradigm in access of legal services for the common man. I also welcome Member Secretary NALSA and Member Secretary SLS, who plays the role of smiths between the common man and legal services institutions. I am confident that the experience shared by the member secretaries would positively reflect on the outcome of this conference. If we trace back the history, the legal services institutions in India, we are primarily guided by Article 39A of the Constitution of India, which enjoins upon the state to promote justice on the basis of equal opportunity, provide free legal aid, and ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Bearing these objectives in mind, Indian Parliament has enacted Legal Services Authorities Act 1987 for constituting legal services institutions at state, district and taluka level. Rajasthan State Legal Services Authority, or RSLSA as it is more commonly known, has been since its inception toiling to realize goal enshrined in Article 39A of the Constitution of India. With the team of 36 district legal services authorities and 181 taluka legal services committees, RSLSA has been relentlessly working towards providing a competent and free legal aid and advice to all the eligible persons and victims of crime and spreading legal awareness relating to all relevant issues. RSLSA also boasts of running 708 legal aid clinics and 52 legal assistance centers in Rajasthan for providing a range of legal services to people, especially senior citizens, persons suffering from disabilities, laborers, and women. Towards its goal in raising 100% legal literacy, RSLSA has conducted 112,463 legal awareness and literacy camps in the year 2022, which has benefited 54,10,456 persons. RSLSA has made it a permanent feature of its action plan and future programs to undertake regular visits to such Rain Baseras in order to make sure that no person is staying or sleeping under open sky or in streets without any roof over their head. Regular inspections of jails, Nari Niketans, children and observation homes, one-stop centers and mental homes are carried out by DLSAs to ensure that such institutions provide all necessary facilities to its inmates and residents. RSLSA has launched various schemes like support to survivors for victims of rape, help to children for the children who have become orphans after March 2020, etc., to provide compensation, legal aid, and other reliefs as and when required. RSLSA is playing an active role in promoting alternative dispute resolution in Rajasthan. RSLSA has adopted result-oriented approach and introduced many new innovations which have further helped in accomplishing new heights in terms of number of settled cases by way of compromise through National Lok Adalat. In this year, for the year's first National Lok Adalat, Rajasthan disposed of more than 30 lakhs cases. This has been made possible by steps like issuing of exhaustive guidelines to smooth out the functioning of the National Lok Adalat, appointment of nodal officers at every juncture to provide necessary assistance, adopting practical approach to settle the bank recovery matters and Section 138 NI Act cases in association with the nationalized private banks and financial institutions, evolving new mechanism for pre-counseling by way of doorstep pre-counseling with the specific timeline amongst any others. The 36 permanent Lok Adalats in Rajasthan are also working towards better public utilities service to the masses. RSLSA receives large number of PLC and grievance applications which are immediately dealt with to provide efficacious remedy to the applicants. RSLSA has always walked the talk and stayed true to its name of a legal services authority where no person has been turned away. I genuinely believe that this conference will bring together the legal services institutions of West Zone as one so that the ideals enshrined in our constitution may become a reality of India in near future. I once again welcome this august gathering and convey the best of my regards to you all. Thank you. Jai Hind.
Thank you very much, sir. Thanks for your words and invigorating thoughts that will surely pave the way forward. Moving ahead, our next dignitary, Honorable Justice Mr. Manindra Mohan Srivastav, has had an illustrious career, an eminent jurist who has a tenure of Honorable Judge Chhattisgarh from a period of 2009 to 21, has given landmark judgments. Thereafter, Honorable Sir has graced Rajasthan High Court as a senior judge and acting Chief Justice of Rajasthan High Court. Honorable Sir is also Executive Chairperson of RALSA. May I request, Sir, you please come on the stage and give your introductory address. Johar, Sir.
A warm and gracious morning. Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairman National Legal Services Authority. Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India and in charge of Consultative Committee. My brother Justice Vishnoi, brother Justice Pankaj Mandari on the dais. Honorable Executive Chairman and Chairman of the High Court Legal Services Committee in this West Zone Conference from representing the state of Rajasthan, Madhya Pradesh, Gujarat, Chhattisgarh, Goa and Union Territory. Honorable judges in the Consultative Committee, member secretaries from different states, judicial officers, ladies and gentlemen. I extend a very warm welcome to all of you in this West Zone Regional Conference being organized at UDAIPUR in Rajasthan. And my grateful thanks to Honorable Chairman NALSA for giving us this opportunity to co-host this zonal conference. The Executive Chairman and Chairman of the High Court Legal Services Committee in this West Zone Conference are representing those states which taken together represent more than 36 crore of population in this country. The significance of this West Zone Regional Conference lies in the fact that a significant percentage of population in these states belongs to marginalized society, scheduled tribe, scheduled caste, other backward classes and other marginalized sections. Therefore, this West Zone Regional Conference assumes great importance. The NALSA has identified certain issues and challenges which is being faced not only in this region but all over the country. These challenges are being discussed and deliberated in various fora time and again, and every time our endeavor has been to find out how our policies have worked, what are those areas which need further improvement, new innovations, ideas to enhance the legal access, the access to justice for all. One of the main area of concern which has always been and is the top of it is legal aid services in criminal jurisdiction. All of us have been holding criminal jurisdiction at one or the other point of time as judges in the courts. I can tell you with my experience when I was holding criminal jurisdiction and deciding appeals, bails, one thing I found that even those cases where the cases were brought to the court through legal aid, there was no distinction being made by the courts insofar as prescribing the conditions on which bails could be granted. A case has come from legal aid, yet the condition for release is 50,000 personal bond with 2 local sureties. The result was devastating. While hearing a criminal appeal, I found that even though bail was granted to him by the court, he could not furnish it. Nobody came forward to tell him or to vouchsafe his cause that this condition could be relaxed and could be released. The result was that the person underwent jail sentence for more than 10 years. So only when his case came to the court for being heard as an old case that it was found. The situation in many places, I cannot say that it has happened in all the places. But since I have the experience of working not only in a state like Chhattisgarh but also in a state like Rajasthan. There is vast population of tribals in the state. Many cases came before the court when we found that the appeals were filed after a very long delay. And before me, at least 5-6 cases had come, sir, where the appeal was filed after 10 years. And most of them were tribals. And nobody helped them, nobody told them. And then I started thinking as to what our legal aid clinics are doing in jails. How is that persons who are languishing in jail are not even provided the legal aid to file appeal? Maybe in other cases that may not be that situation, but it is there. It is my personal experience. So that is one area of challenge which we are still facing. That gave us an opportunity to find out where are the loopholes, how the inmates in jails are being dealt with, who is looking to them, looking after them, how their rights are being apprised, that you can file an appeal, you can move an application for grant of bail. That is one area that we need to ponder, and in this West Zone conference, this particular aspect may be considered, best practice may be shared, and also challenges. The other aspect which I wish to highlight here is that the rehabilitation practices which are being followed in jails are age old. Still we find that some carpentry, something like that is being followed. When I visited jail, many of the inmates, mostly youth, said we are not getting enough opportunity to educate ourselves in modern subjects. Many of them were inclined that if we are provided computer education after we complete our jail sentence, will come out and will help us to rehabilitate in a better manner. I inquired as to how the arrangement for studies is being arranged, said that IGNOU is providing them education and also granting them degree. But the subjects are very limited. So I had to collaborate with the state universities, and they said that we can also provide distance education. We have modern distance education programs which are in computer also. So we can provide them. So that this is one area which also needs to be considered. What kind of rehabilitation practices are in place in various states? The representatives from various states have come today, and they may also share what kind of vocational services are being provided in jails. Rajasthan is one state where open jail system is in vogue since 1972. An enactment was made. And recently, Honorable Justice Kaul visited Jaipur in one of the open jail, and we interacted with the inmates who were identified on certain conditions to reside in open jail. They were allowed to move out once in a day for a few hours and then to come back. Their experience was that this has helped them to reintegrate in their society once they complete their jail sentence and come out. This is one experience which I think is something which can be shared with all of us. In what other states, what kind of practices are being followed, how are the open jail systems working, if at all, in those states, what are the other ways and means of operating this open jail system, would also be a matter of consideration for all of us. So is one aspect as far as victim compensation scheme is concerned. As we all know, in view of Supreme Court judgment in the case of Nipun Saxena and other judgments also, victim compensation scheme has been framed in 2018 for certain category of disadvantaged group. The states are also having their individual victim compensation schemes. As far as victims of POCSO are concerned, they are governed by the provisions contained in section 38 of the POCSO Act. At times we find that these different schemes in their operation create some kind of confusion amongst those who are to decide the cases of victim compensation. In the state of Rajasthan, victim compensation scheme is being operated in such a manner that in cases where the victim is a person of hit and run, his cases are not taken up. And later on it was revealed that because cases of Motor Vehicle Act have been excluded altogether, even though that person cannot go to the court and get any compensation through the mechanism provided under the Motor Vehicle Act, he is completely ousted. The compensation which has been provided, the maximum amount which is presently provided, that also needs to be revised, because for the state and under the NALSA scheme, different amount has been provided. In some cases, there is scheme for appeal against the order of victim compensation, but that has not been applied uniformly. It would also be a matter of discussion as to how this victim compensation scheme can be effectively operated so as to provide benefit to the class which are in need of proper compensation. So the Lok Adalats which are being held, certain category of cases needs to be identified, and apart from motor accident claim cases and disputes in the family, a new area of litigation and concern has emerged, and that is cases under NI Act. As far as state of Rajasthan is concerned, out of 22 lakh odd cases, 6 to 7 lakh cases are only of NIA cases. So what we did that this time, last 2-3 Lok Adalats, we concentrated on these issues as to what are the ways and means of getting these cases also effectively dealt with and through Lok Adalat settled. We found that the cooperation of the banks in this regard, for reasons best known to them, was not up to the mark. We requested the banks by sending the list of cases that these are the cases where cases are pending, we are taking up in Lok Adalat. Please inform us that even according to your one-time settlement scheme, what is the amount at which it can be settled. But the bank is not prepared to provide those lists. Our idea was that once we give a notice of pre-counseling, we will show them that amount, and that would be easier for them to consider whether we should settle on this amount. So that is also, sir, one of the area which needs to be taken care of. Much has been said about the pre-litigation cases, and it is happening everywhere. But we are concentrating much more on the pending cases. And in last 4-5 Lok Adalats, apart from pre-litigation cases, almost 10 lakh cases which are pending in the courts have also been decided and awards have been passed. In this manner, we are also trying to find out ways and means how to deal with the family matters. Because there, once even a case of 125 CRPC for maintenance is decided, that takes care of number of litigations which are generated because of the dispute between the parties, which are invariably domestic violence, divorce matters, restitution of conjugal rights, 125 maintenance matters, and other kind of connected disputes, criminal cases, 498A criminal cases which are instituted against one of the party by the other. So that is one area we are trying to find out how it could be settled as early as possible. Motor accident claim cases have also been taken up on priority basis, because we feel, sir, that if the family of the sole earner gets that amount, at an earlier point of time through settlement, it serves a great social purpose. I am sure that this West Zone Conference will concentrate on the issues and challenges which have been identified by the NALSA to improve the overall functioning of Legal Services Authority in the state under the dynamic leadership and guidance of Honorable Justice Sanjay Kishan Kaul, our Executive Chairman NALSA, and Justice Sanjeev Khanna, Judge of the Supreme Court. Thank you very much. Jai Hind.
Thank you very much, sir. Thanks for your words and for your ideas. And before I invite our next guest, Honorable Chair, I would like to say a few words about him, our next speaker, in his special address, about him and about his illustrious family. Honorable Mr. Justice Khanna, an alumni of St. Stephen's College, is the son of a former Delhi High Court Judge, Mr. D.R. Khanna, and a nephew of India's one of the finest Supreme Court judges, Mr. Hans Raj Khanna, whom we all remember for his decisions on civil liberties, his crusade for personal liberty, and his profound views on habeas corpus, the famous case ADM Jabalpur versus Shivkant Shukla, that has gone down in the annals of legal history as a guiding light. The great Nani Palkhiwala, in his book, We the People, mentioned, and I quote, when he, that is Mr. H.R. Khanna, pronounced his glorious dissent in the habeas corpus case, the New York Times remarked that surely a statue would be erected to him someday in an Indian city, unquote. Honorable Mr. Justice Sanjeev Khanna, sir's views on jurisprudence are widely acknowledged. Sir's views on equal and access to justice echo in his judgments, and his judgments are testimonies to his erudition and fine sense of judgment. Honorable sir, I request you to please come and share your views and provide us the way forward. Thank you very much, sir.
Namaskar, respected Mr. Justice Sanjay Kishan Kaul, sister and brother judges, executive chairpersons, secretaries and members of the various legal services authorities, High Court legal services committees. I'm grateful to the acting Chief Justice, Mr. Justice Srivastava, because he has set the ball rolling. I'm going to set forth what I believe are the various functions and issues and how we should progress from now onwards. I had earlier in the first conference we had at Varanasi given a PPT presentation. This one is going to be quite similar to that with some modifications and changes. One of the things which we have not acknowledged is the success and achievements of the legal aid system in India. With our interaction which we have had with some of the foreign judges is that they do not have any such system abroad. In fact, most of the times the taxpayers are reluctant to give or provide for legal aid to the persons who are being now prosecuted as accused or who has been convicted. In fact, to get legal aid in appeal once you're convicted is very difficult. So we have in a way set a benchmark for others to follow. And what is the reason for that? I feel that the reason is quite apparent. The reason is that we believe in constitutional principles more than anybody else. So I'm going to start with you from some of the articles in the Constitution which we very often read, but probably miss out on the significance they have as far as access to justice and legal aid is concerned. If one looks at Article 38, I'll start from the bottom article, Article 38. It says, this is from the Directive Principles of State Policy, the state shall strive to promote the welfare of people by securing and protecting a social order in which justice, social, economic, political, shall inform all institutions of national life. If we come to Article 39A, which we all know is the predecessor and that led to enactment of the Legal Services Authority Act, the state shall secure that the operation of legal system promotes justice on the basis of equal opportunity. Just pausing here for a minute, the word used over here is secures justice, which is far more very powerful and a very authoritative word. So the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity. Then we come to Article 21. No person shall be deprived of his life or personal liberty except according to the procedure established by law. This lays down importance on the procedure established by law, and for that we again refer to Article 14 and 22(1). What does Article 14 say? If you read it in light of Article 21, no person the state shall not deny to any person equality before law or equal protection of the laws within the territory of India. So the importance of the procedure should be that it should not deny equal protection of laws within the territory of India to any citizen or any person. Article 22(1). No person who is arrested shall be denied the right to consult and to be defended by a legal practitioner of his choice. Now the importance of this lies in, if a person cannot afford a legal practitioner, how do we provide him access to the legal practitioner? Now I'll elaborate on this aspect, but before I do that, can I just also refer to the glimpse of what is the issue, what is the challenge before us. Section 12 of the Legal Services Authority Act provides the categories of people who are eligible to legal aid. If one takes that into account, almost 80% of the Indian population, consisting of about 1.3 billion, is entitled to legal aid. This makes India the largest country in the world which is covered by the legal aid system. If one has a glimpse of what we have, the legal aid in India, the different authorities, we have 37 state legal authorities, etc., etc. You can have a look at those figures. But look at the figures of the panel advocates. We have about 50,000 panel advocates, about 45,636 paralegal volunteers. And what is interesting, if you look at the figures of the paralegal volunteers, is that the percentage of women is almost 40%. It's something to be acknowledged and proud of, because this will help us dealing with several ticklish and difficult issues, sensitive issues. Now, the primary difficulty as far as legal aid is concerned is access, and our topic is ease of access and tackling apprehensions in the slide. The first issue is making awareness to the people about that they can avail of the legal aid facilities or different schemes which we have propounded. Literacy, accessibility. I've used two terms, reach out and reach in. Ease of access means reaching in, where we have set up our institutions where the people walk in and get access to us, and we provide them assistance. But more than that, we have to also develop a system by which we reach out. That means legal services institution approach the beneficiaries themselves. This is the area in which we have to work, because otherwise we will never be able to identify Because until unless the person beneficiary has the knowledge and is aware that legal system or these are the facilities available, he'll never be able to get access. So we have to somehow develop a system by which we can reach out to them. The other thing is there are two apprehensions which almost every citizen faces when he approaches us for legal aid. First is the authority an extended arm of the state? We have to clarify and allay all those fears. The second is the quality of legal aid. These two issues have to be addressed side by side. Without addressing them, we may not be able to move forward and have ensured that the constitutional goals are fulfilled. We have done a lot of work in this regard. We have about 22,321 legal literacy clubs in schools and colleges. We have, if you look at the figures, the issue which arises over here is our legal services helpline numbers. These require upgradation and these require improvement. We have about 11,802 legal services committees, out of which 1,119 established in the court complexes and jails. Whether they require further addition on how do we do it, do we have roving clinics from jail to jail so that we can utilize our staff structure very well, but in a much better way with one of the issues which can be examined. Now coming to the real effect, when do we provide legal aid? What stage are we providing legal aid? If one looks at it, our primary emphasis has been at the trial stage and the appellate stage. The pre-trial stage somehow is not that much, we have not really paid that much attention to the pre-arrest stage. The pre-arrest stage the pre-trial stage consists of pre-arrest stage, arrest stage, and the remand stage. So for each of the three categories, we'll have to adopt a strategy to how to deal with it. It's in fact at the pre-trial stage that most of the poor, economically and socially, are most vulnerable. It is at that time they are not aware of their rights, they are exploited, and invariably, by the time they realize that what has happened, it's too late. They have lost all whatever they had, economic wealth or whatever savings they had. In fact, the President of India, when she was speaking at the Law Day function, pointed this out and had indicated that in some cases the situation is such that the families just leave the person who has been detained because they cannot afford, or don't want to lose whatever they have, small little, with whatever is their savings, they don't want to give up on those. So this part, in fact, we have early access schemes, but how much they are being implemented, to what extent they are being implemented. You see, the Legal Services Authority, Section 12 of the Legal Services Authority Act uses the term custody and not arrest. Custody is much broader than arrest. It's prior to the arrest also. As soon as a witness or a suspect comes in contact with the police, he's in custody. So our role commences from the day when a person is summoned by the police, either as a suspect or as a witness. The pre-arrest stage, if one looks at what is the effect, what is our role at that stage, is making the suspect feel that he's not isolated and should not get intimidated. Safeguarding their rights as per law, keep a check on the police aggression and abuse of power, avoid unnecessary arrests, gaining vital and image timeline sensitive information on evidence for the suspect's defense, which may not be available after a passage of time, protecting the suspect from being subjected to wrongful self-incrimination contrary to the constitutional and statutory protections. We have, in fact, in Prakash Singh, referred to Police Complaint Authority, but I'm not dwelling that on much, but just for the sake that the Legal Services Committee should be aware that there are police complaint authorities which have been established in terms of a judgment of the Supreme Court under which these issues can be raised. This is a little disturbing figure. Slide has not moved. one looks at this figure, there were about 1.5 crore arrests in 2021. If one looks at this figure, that means almost 1% of the Indian population was arrested. More than 1% of the Indian population was arrested in 2021. This will be more than almost 80 nations in the world. This is and therefore when I said about pre-arrest stage or pre-trial stage, this is the figure. And if one looks at the second part of it, 61% arrests were under the CRPC provisions, where people don't even come to court. And 39% arrests were under the IPC provisions. And what does it mean in real terms? About 89 lakh people or persons were arrested under the CRPC. And about 58 lakh people or persons were arrested under the IPC provisions. This is a point which we have to consider and something which we should be conscious of. Now we turn to the next figure, is with regard to the total number of prisoners admitted in 2021. There's a difference between, you'll find that figure mentioned is 18 lakhs. The reason is this: those who are arrests, these are persons who have been sent to prison. So there's a huge gap between the persons who are arrested and persons who are sent to prison. Now if one looks at that figure, about 18 lakh people were admitted in prisons in 2021. Out of it, the under trials were almost 94%, and only 6% were in the name of which were the ones who had been convicted. The other figure, if one looks at, is the person who are released from the prison. That's about 15,71,000. So there's a gap of about 3 lakhs, 2.5 to 3 lakhs, which is emerging. So the people going to the prison is in excess by about 2.5 lakhs. What is more even disturbing, which is not there in the slide, is the factum that there has been an increase by about 10.8% compared to 2020, the people who are being sent to prisons. And also the number of under trial prisoners has gone up by about 14.9% compared to in 2021 compared to 2020. And if one looks at the last figure, it gives the total number of persons who are in prison is about 5,54,000, out of which almost 71% are under trials, and about 77% are under trials, and about 22% are the convicted. We all are aware of the DK Basu guidelines. I'm not referring to them, but is there a need to integrate our system so that we can have real-time like access to registration of FIRs as well as arrest of person? It's another issue whether we can do it, how we should do it, whether the state authorities we can, and will that help us if we have real-time access when a FIR is registered or a person is detained or taken into custody. I'm now dealing with some of the figures relating which we have been able to collate with regard to pre-arrest, where the legal services authorities and the committees have interacted. In about 11,505 suspects were provided from 2019 to September 2022, were provided legal assistance at pre-arrest stage at the police station. About 4,246 suspects were not arrested. Now compare this with the figures we have with regard to the arrests. One can understand the gap which is emerging. Then about 10,462 arrestees were provided with legal assistance at the police station prior to producing them in the court. Again, the gap is quite large. Where we improve upon our figures is the providing of legal assistance at the remand stage. There we have gone up to the figure of 1,13,614. The total number of bail applications filed, again we come down a little. is about 39,092 bail applications were filed at the remand stage and about 19,177 arrests for granted bail. Now, we have now introduced the modified scheme for Legal Aid Defense Council System 2022. This scheme, I believe, will be coming up should come up for consideration before us. Do not put in the slide. I'll just point out certain aspects which we can go into as far as the scheme is concerned. One is physical infrastructure. The second is human resource eligibility criteria, capacity building, outlining of standard operating procedure, challenging and filing solutions to the various aspects as far as the performance is concerned and how to evaluate the performance, resizing of the panel. Then obviously another aspect relates to delay in filing of the appeals and their solution. How do we interact with them? This project if one looks at we have implemented in the stages, and by 31st March, that is this month itself, we should be able to implement it in almost all places. As far as I know, about 679 DLSAs have been already covered by this scheme. Then we come to the schemes we have. There are about 12 schemes in all. I believe each state will have its own focus on which scheme is more lagging behind, which scheme is being implemented in a proper way in each of the states. But the four important schemes are victims of trafficking and commercial sexual exploitation, legal services to the victims of drug abuse, eradication of drug menace, acid attack victims, and disaster victims through legal aid services. We also have schemes for differently abled children, widows, senior citizens, workers in unorganized sector, child-friendly, children for children protection, mentally ill, mentally differently abled, etc. One of the issues which I have seen coming repeatedly in the courts when we have dealt with the habeas corpus petitions is the reluctance of the girls to go to any of the Nari Niketans. That's a huge problem, at least in Delhi, because Delhi is a very cosmopolitan place. A lot of migration has taken place, and that must be happening in towns also, all over, wherever migration is taking place. And our urban population is going to keep on increasing. Percentage of urban population is going to keep on increasing. So their borders are not there. The intermixing is much more. The children who are coming up are going to schools, colleges, and there the barriers are being broken. But unfortunately, parents do not at times accept, and they are more traditional status quo, and they are not able to accept that. How to deal with that situation is a problem. I had in the High Court when I was a judge, I realized that as a judge, when I speak to them, probably they do not open up. And we also don't have so much time to how to deal with that problem. So the solution found by me was I'll ask the Legal Services Committee to send some lawyers. They'll interact for about an hour or two with both of them. And then I'll interact with first with the Legal Services Committee panel advocates, and then with both the boy and the girl, probably find a solution. Sometimes you find a solution, sometimes you don't. But the problem, how to address this problem, is going to keep on rising, at least in many of the high courts. May not be so in some of the high courts, but many of the high courts, this problem is going to be there, and we have to be able to tackle the problem. As far as victim compensation scheme is concerned, and C357A is concerned, how do we ensure that in cases where the compensation is to be paid and somehow the trial court has missed it out, how do we ensure that we keep on updating or informing the judges concerned that probably there's been an error, and please ensure that 357A is implemented. We have to be also what I call as social auditors of the existing facilities available under the schemes. we act as converging nodes, whether the government schemes or our schemes are actually reaching out the persons concerned who deserve the same. Mention was made about rehabilitation, and their skill building and employment on the corporate social responsibility is one of the issues which can be taken up, which can help us. Of course, there are other ways to also deal with it. We have to become contemporary. You can't teach skills which are outdated already, and it serves no purpose. There's a big problem because when they come out in the open after the halfway homes or open jails, then they again face the same problem, and they invariably go back to crime because there's no other revenue or opportunity for livelihood as a normal citizen. The statistics with regard to the victim compensation scheme, if one looks at, about 16,000 applications were received, and we have been dealing with it, but pending applications about 16,361. We have the reason why I've referred to it is each legal services committee or the authority must keep a track of what is happening. One aspect which we have sometimes ignored is the witness protection, which is again provided for. Because the witnesses are eyes and ears of justice, we always rely upon them because we convict them based upon legal evidence, not on a moral conviction. So here is the item number 4, if one looks at, to provide a range of protection, anonymity, temporary residence in a safe house, new identity relocation. So each judge has to be, or we have to sensitize the judges that there is need, because if one looks at the figures of number of public witnesses which turn hostile is fairly large. I did this little research of about 100 odd cases which I dealt with in the court in about 6 months or 8 months, and the figures were almost 40% were completely hostile. The figure in Delhi is 40%, I guess other places were much larger. 40% means completely hostile, means they did not say even a single word. They were partially hostile, will be another figure. But that study has obviously not been done at a large scale. These are tentative figures. The figures may vary. I'll skip this. The other element now is in terms of the Commercial Courts Act. Now we are involved with mediation. So this gives a, next one. Next one. This gives, okay, I'll take a little time. There is, as far as what I have been able to understand, the figures are not very good as far as the mediation in the Commercial Courts Acts are concerned, though it's improving. In 2019 and 20, only 167 cases were settled out of about 18,000 cases which were referred to mediation. 2021, the figure has gone up to 186 out of again 18,000 cases which were referred. In 2021, about 32,000 cases were referred, and can move forward, please. And about 368 cases were settled, but the figures in 2022 up to September show that the number of cases which have been settled is 473. What is important is that the figures are going up every year, so one doesn't have to be despondent. There have been huge successes in mediation in certain places, certain courts. Why is it not being replicated in other courts is an issue which must be addressed. And these are the figures if one looks at. So, and these are figures only up to September 2022, so one can take it that 6 months hence, the figure will be reaching about 1,000 cases successful mediation, which is a huge success. One aspect, other aspect which we have probably neglected is the community mediation. That is, it can be from neighborhood, family, school, commercial, miscellaneous. So these are, if one can change the next slide. These are aspects which we have taken some steps in Delhi with regard to community mediation. I don't know to what extent it's been successful, but I think a lot of litigation can be cut because small little disputes are coming. What I can see with I get the SLPs in the Supreme Court, very, very small, insignificant issues become big ones because they are not tackled at the right time, in the right way. The benefits of community mediation are there. The other aspect relates to premature release. There, again, the statistics will show that there were 93,000, yes, but this I'm going by the Prison Statistics India Report 2020. About 93,000 convicts were released, out of which 45,000 were released on completion of sentence. That means almost 50% of the persons released from prison were released on completion of sentence. 43,000 were released on bail or suspension of sentence, and the total number of prisoners who were released on prematurely is 23,350, which is approximately 1.9%. I've already given the details. This one you already have with you, so I've already given those details. We have, in fact, we have now, in terms of the judgment of the Supreme Court in the human conditions in 1382 Acts, provided for 14 categories of cases where the under trial review committees in every district have been set up, and they have to review those cases. These 14 categories, can you go a little earlier? These have to be taken into account. They are fairly interesting categories which have been identified. Compoundable offenses where the accused is not able to provide for security. This one has not been able to provide for security. Unsound mind, otherwise accused is entitled to bail, statutory bail, etc. Also, there's a category where accused are between 19 to 21 years of age, and the offense is punishable by 7 years of imprisonment. They have already suffered about 1/4 of the imprisonment. 437(6), where cases are triable by a magistrate. The trial of the accused on non-bailable offense has not been concluded within 60 days from the date of first taking evidence in the case. The other aspect of rehabilitation and reformation is something we have dealt with. One thing is very clear: until unless we believe that the accused are one of us, until unless we believe that the accused are us, they are like us and not one of us, that approach is not acceptable. Because somewhere down the line, they were not born criminals. Somewhere down the line something went wrong, and why they took to crime, why did they commit the crime. Probation of Offenders Act, again, both under the probation or on the CRPC, is something which has been lacking. We have not been able to really achieve what was the objective of the legislation. To some extent, we are responsible because we have not invoked these powers. Probationary officers is a problem. To what extent the legal services committees and authorities can step into it will be an issue which we can examine. One area where we have been successful is Lok Adalats, and it's done fairly good. We have very good figures if one looks at the next chart. In fact, the figures, if one looks at 2.8 crores in 2022, 2023, we have already crossed the figure of 2.1. Probably by the year end, we should be touching about 5 crores, which is a phenomenal figure. I think this is one area we have been very successful. The last aspect which I want to point out is with regard to how do we now evolve and make ourselves more easily visible, and how do we take use of the technology, IT technology, to ensure that we are aware of what actually is happening. The figures sometimes are available on the core, but it's a breakdown of the figures which is very important to be able to analyze it, know exactly whether we are doing what we want to do or we are faltering somewhere. So the breakdown, etc., what are the breakdown methods or what are the breakdowns we require is to be required, because moment we have the figures with us, a dashboard of figures with us, we'll exactly know where we are faltering or where there's lapse taking place or where we have improved and why we have improved. Thank you so much. It's been a little technical, but I hope we'll be able to make out. So go ahead in the we'll set up the road model for the future. Thank you.
Thank you very much, sir. It was indeed a special address. It had to be technical also, in fact. Uh, Moving on to next section, a strong society is also a legally empowered society. RALSA, with the objective of legal aid and empowering women and children, has published 2 books. These are Kanuni Sahayata 101 प्रश्नों में and Kanuni Sahayata 101 प्रश्नों में is about dealing about these are basically the FAQs wherein people can understand, frequently ask questions and understand and ask questions about it. Bal Rachnaएं, honorable guest, Pantheon participants and those that are present here. Bal Rachnaएं are written by children of the age group 6 to 10, 11 to 15 and 16 to 18 years of age. In these creations, you will find their aspirations, dreams, hopes surpassing the walls of 144 children of Rajasthan where they reside. Thank you very much, sir. Before I request our chief guest to address the dignitaries in this room, I would like to speak a few words about him, and it is indeed my privilege to say a few words about such a tall figure. Honorable Justice Kauls hails from a distinguished family of Kashmir. He belongs to the family of Raja Suraj Kishan Kaul, Sir Daya Kishan Kaul, Raja Upendra Kishan Kaul, who all had distinguished careers in their public services. Honorable Justice Kaul's brother, Justice Neeraj Kaul, was a judge of Delhi High Court. Your Honor had a distinguished schooling from Modern School, New Delhi, and a college from St. Stephen's College, New Delhi. While preparing for this occasion, I did some research on him, and I feel privileged to share with you that Your Honorable Mr. Justice Sanjay Kishan Kaul has been an ardent follower of mediation. Sir, in his address in Banaras in the Northern Regional Conference over Legal Aid and Indian Judicial System, said, and I quote, "The broad parameters of which the justice system is evaluated are availability of justice, accessibility of justice, and its deliverability. If I may say so, the equality of opportunity of justice is the base," unquote. Honorable Sir is also concerned about the issues of under trials and bails, and his views on bails and litigations are profound and resonate with great Justice V.R. Krishna Iyer. Justice V.R. Krishna Iyer, I pioneered the legal movement aid in the country. Incidentally, today we are in Rajasthan, and here only in 1978, the great Judge Mr. V. Krishna Iyer, in his landmark judgment, State of Rajasthan versus Balchand, alias Bale, propounded, bail remains the rule, jail is an exception. Honorable Sir also believes that technology can be a lever in the legal aid and Indian judicial system. May I request you, sir, to please come in your keynote address and share your views with us. Thank you very much, sir.
Brother Sanjeev Khanna, Acting Chief Justice Srivastav, eminent brother judges on the dais, off the dais, ladies and gentlemen. It's a great pleasure to be in this historical city and a city of lakes. And in this concept of diversity which we talk about, it has been an endeavor of the NALSA that we will take these regional conferences and other conferences to parts of the country which have not had the benefit of having a local function there. So for example, in Rajasthan, everything used to happen in Jaipur. So we said, let's take it to a different venue, part of the same city. Similarly, next we're taking the east of India to Meghalaya, part of the northeast in a very important area. So let me begin by saying that the purpose of these conferences is not to have a monologue by us. I always believe it's the interactive sessions which are more important. We're here to see and find out what you think about it, what are your regional experiences, and how can we correlate that regional experiences and take the benefit of it at a national level. Cliche, but yes, the concept of access to justice is based on constitutional and legal framework and how it operates. And so from times of the Magna Carta, that to no one will be sold, to no one will be refused or delayed right or justice, the very establishment of the Legal Service Authority is towards this objective. We have a diverse country, very varied country, quite number of people in this country with different problems. Large number of them socially and economically disadvantaged. So therefore, they have an unequal battle when they run on the wrong side of law. And the very objective of the Legal Service Authority is to see how we can assist them. Some figures have been given of the success of Legal Service Authority. Matter of pride. But let's keep in mind that statistics and diamond statistics are something we have to be careful about. So at times I used to raise this question to myself that if we can settle so many lakhs of cases, millions of cases, why don't we settle a few thousand cases in courts? But it has an important role. See, the one important role is that when we talk about pre-litigation settlements, local adalats, mediation, you are preventing that dispute to go into a litigation. It has own significance, certain significance, because it prevents accreditation or unnecessarily accreditation to the number of cases pending in court. That's one aspect of the matter. The other is to acknowledge what we have done, to learn from what we have done, to see how the future lies. While it is necessary to be self-critical, it is also necessary to be proud of what we have done. Because unless we are proud of what we have achieved, we'll become like the newspapers of the day, which are only critical of what is happening. Therefore, some aspects which I wanted to highlight were that look at the COVID-19 times, how difficult it was. But the Legal Service Institution adopted, the whole institution and the Legal Service Authority, taking initiatives in the form of e-loc adalats, legal aid case management, legal service management system. So difficult times has produced and helped us in innovation, and this is a constant process. We have to keep on introducing new schemes and new processes depending on how the society is working, where the problem lies, and as we increase our access, as we increase our footprints, we will come across different challenges, and we will have to keep on innovating to produce the solutions to them. There have been very many, as Justice Khanna said, new dimensions to legal aid introductions. The Legal Aid Defense Council system is a breakthrough in legal aid machinery, and I think very important. Most developed countries have an equally managed and I would say powerful prosecution system and defense systems. In both these aspects, there are considerable need of improvements in India. One, it is the job, I believe, of the prosecution to see the worth of the material for prosecution and not take every case for prosecution, as it happens in our system. The prosecutors, unfortunately, do not accept responsibility and would like to let the court system decide rather than take the responsibility where they feel that there is not enough material to proceed with. That's one aspect. Therefore, the court's role becomes more proactive in this. I think one of the important areas of concern is framing of charges. That is an important stage in the criminal justice system. As I believe, framing of issues in a civil dispute are a very important stage of the proceedings to determine how the trial will proceed. Then, how do we improve the defense systems? Because to give, if you're talking about the primary role of the Legal Service Authority, it is to assist the people who have fallen on the wrong side of law, maybe rightly, maybe wrongly, to give them the best of assistance, to give them available the rights. So, full-time involvement of defense counsels and a dedicated infrastructural support for it becomes extremely important. I'm given to understand the scheme today is implemented in 377 districts so far, and we are at the final stage. It's something to be, I think, proud about, and now how to take it further and improve its implementation. Similarly, adaptation and upgradation of mediation and amicable settlement is another area, which I'll revert to a little later. Yes, as the introduction said, I'm passionate about it, do believe that's the way forward. Therefore, the Legal Service Authority not only has to increase the access, but also take strides in terms of innovation and methodologies. Another very important aspect is the under-trial review aspects and committees. This is Khanna pointed out as to how many, 1.5 crore, 1% of the population faces arrests. Is it not a matter of concern? Are we required to put this more forcefully in public domain for public and authorities to realize what they're doing? Solution doesn't lie in putting everybody behind bars. Yes, in a country like ours, people will fall foul of at times of the legal laws. The under-trial review committees have been held, I am told, about 9,500 meetings in the year 2022. 60,000 UTPs have been recommended for release, of which about 28,000 have been released in 2022 itself. I have had the opportunity to monitor it also judicially, with very good assistance provided from the Legal Service Authority and from the Legal Services Committee of the Supreme Court. They are trying to manage this issue by involving all the state legal service authorities, involving the police. We are at a stage of development now. The next stage is that the technology will be such that if you grant bail to somebody and within 7 days he is not released, it will pop up as something which will require attention. So the idea is that when, say, a condition of bail is not fulfilled, it should not be, as Brother Srivastav said, come to light when you hear the case. It should come to light at the stage when it is arisen. Technology is extremely useful for that purpose. So when we talk about an indicator there, it will help in knowing that why is it not released? Is it a fall of the system? Is it his unfulfillment of some condition which he is not able to do? So the endeavor to have a synergy of technology, of better assistance, should be able to help in this area, in my belief. Coming to the nature of litigation we have. Litigation in our system is like going to a hospital. There is very little success story. By the time the litigation ends, you are exhausted, and when you see in Supreme Court a lot of matters settled there, I feel, because litigation fatigue is set in, not because of any other reasons. The system doesn't provide at times for settlement at the base level at the initial stage, as Brother Khanna put it. If that was there, the small disputes would get sorted out. I do believe the legal fraternity must, with so much of spread of mediation now, help these alternative dispute resolution mechanisms, assistance to people to sort out their problems, and there are no inhibitions or restriction on what kind of cases can be sorted out. Yes, hardcore criminal cases aside, I believe there is no, whether commercial, family, revenue matters, even outflow of criminal cases from civil disputes. Like in every matrimonial case, I say there is a bouquet of cases, I call them. The lawyer has devised some 5-6 cases which must arise out of every dispute. They are really in the nature of a of a family dispute which outflows into a criminal dispute. All these are capable of sorting out. After all, whenever settlement takes place in Supreme Court, we are the only one who have this privilege under 142 to keep granting divorce. And we keep going, at least I can say of experience, I have been liberally granted wherever. Sometimes I am very happy to see some people combine together also. That also happens. But this helps in also quashing. Every of them has some prayer of 5-6 quashes which will occur, withdrawal of cases. So when you sort out one dispute, as a statistics you are sorting out apparently 6 disputes. And as a reflection of pendency, those 6 disputes are being reflected as pending disputes. Apart from the fact we have this notion that we have so much of pendency. Well, pendency in areas are 2 different things I keep on emphasizing. A pendency becomes in areas when it doesn't get resolved in a reasonable period of time, whatever may be the time stipulated. After all, we are a large country. We are talking about access to justice. We are expecting people to come forth and assert their rights. Then cases will arise. So the challenge is why are cases more in some states, the older cases, and why less? So 2 states where I had an opportunity to serve was Punjab and Haryana on one side and Tamil Nadu on the other. So with similar, I would say, filing, broadly similar findings, similar judges' strength. The old cases pendency in Punjab and Haryana was under 3%, more than 5 years old. In Tamil Nadu, it was 24% when I did this. So I tried to research why is it happening. With some emphasis, we were slowly able to bring it down to about under 18%. But the concept given was, well, the regional footprints of Punjab and Haryana are small. Chennai has Tamil Nadu has a lot of adjacent borders. People escape out into different states and it's difficult at times to find them. So each area would have its own problems. Why is it that some of the smaller courts have less of a problem and some of the other states have a huge problem? In Patna, when I talked to the earlier Chief Justice, with the introduction of a law like the prohibition law, nobody did a legal impact study. How much cases will it generate? With the result, the High Court 16 out of 23 judges are sitting on bail matters. Now look at the scenario. These are startling figures when we look at the problem at hand. And we force from the Supreme Court that, okay, they diluted the first time offence, they should be released, and there's a continuing process how to see. What should have been done beforehand, before introduction of a litigation, not having done, sudden impacts come. In all these, again, the Legal Service Authority has a very important role to play. After all, everybody is not a bootlegger. There are a large number of consumers. If somebody is bootlegging, there's a consumer also. And why is that happening? So, in West Bengal, I come across all these drug cases which are medicinal ones. Some expertise that all these cough syrups are being used for drug use. So, each area has its own special problems, and the local legal service authority at times can reach out as to why these problems are arising. Why I emphasize on mediation so much? Let's understand our legal system and structure. We have framed laws based on our experiences, which we think is how people should be governed. That man really may or may not know the law. He is concerned with his problem. The legal system tells him, your solution is this. He doesn't know whether that is his solution or that is not his solution. And he may not like the solution which is offered to him. But it's a compulsion arising from legal adjudication which is forced on him. On the other hand, when you have settlements, we have lok adalats, you have mediation processes, you are able to tailor-make and model solutions. So I don't look at mediation as a methodology of creating only an alternative pipeline to reduce pendency of cases. But I do believe that in many areas it is a better solution, provides a better solution than would provide in a litigation. So 2 examples I often give and I repeat is of a case of an infringement of IPR case which came to court. The court would grant injunction, would grant damages. That's the normal solution. But some judge thought that why not look into whether this can be resolved, pure commercial dispute. in the course of arguments, though the price differential was great, it was said that, look, there is brand dilution because the quality of the product is excellent. So therefore the chances of deception are higher. And what transpired from it was that the foreign brand always looks at times to manufacturing areas. And this originated from Ludhiana, which is the area of production. And they, in turn, instead of litigating, they agreed to the infringer becoming the supplier of the person who was a foreign brand. It will not come into our mind. It cannot. The legal system cannot take this scenario. This system of thrusting a solution as against a solution emerging from the parties is visible at times in court. I see sometimes the litigant at the back will look very agitated if you've seen in court. He feels what the lawyer is saying is not his problem maybe. Maybe the lawyer is putting in a legalistic way. For somebody like me who was very strict that a litigant should not be permitted to speak, going through a process of mediation, myself going through a training, being involved, has been a changing experience from my role as a judge which helped me. And at times, I used to find, okay, let him have his two-bit word. Maybe he's able to feel that he has had his say and what he is saying. So one of my good friends and colleagues at the bench gave me an actual example of what happened. And I think that sum and substance sums the whole situation up. So in the Delhi High Court, in the outer periphery are these khokas, small khokas where lawyers go, have tea, coffee, etc. One of them serves cold drinks, milk, cold coffee. Some lawyers were standing when these two people come in, suffering litigants. They came and ordered possibly cold coffee. This fellow gave them that masala milk or something. So he asked them, "Ye kya diya aapne?" उसने कहा, "मैंने मसाला मिल्क दिया." मैंने मांगा क्या था? मैंने तो कोल्ड कॉफी कहा था. So he turns to the other person. He says कि पिछले जन्म में जज होगा, मांगो कुछ और देता कुछ है ये. See, this is a reflection of what we are. We thrust a solution on him. He doesn't know why it has been thrust on him. Therefore, the importance of mediation in trying to work out a solution tailor-made for that person and maybe for both the persons. That's why you begin a training in mediation by saying, look, the law can only divide the orange into two parts, but the mediator will endeavor to work out that if one of them is in need of the juice and the other is making a jam, you will give the rind to one and the juice to the other. And in most developed countries today, I had an opportunity to go to the US and look at the mediation process there twice over. 3% cases go to trial. Less than 3% cases go to trial. We have still 99% cases going to trial. How can any system in the world, with all its efficiency, cater to 99% trials from the trial court? Then they will file an appeal and they'll go right up to the Supreme Court, especially if it is a government or a public body. Nobody accepts responsibility. So therefore, a challenge in mediation is to see that the public body is also coming. Example was made here of a negotiable instrument act. Now, why shouldn't the banks be interested in sorting out the problem, to my mind? They must be persuaded, goaded to do so. Sometimes they don't want to accept responsibility. That's the issue. This arose even in motor accidents claims. Now, that's another area which has been by me judicially monitored, where now we've roped in all the insurance companies, the government of India, the state governments. They've devised a software themselves by which when an accident occurs, immediately issues like FIRs, others, there is a system of collection of whatever is required for it. And the insurance companies to be able to disburse the compensation when it is required. There are hundreds of crores of compensation lying deposited in courts, not being released because the process doesn't facilitate an easy release. So the money of the insurance company is locked in deposit, while on the other hand the beneficiary doesn't get it. You need it when somebody passes away. If you're not giving that benefit, then he will settle for less because he needs it now. That 6 or 8% interest cannot solve his problem 10 years down the line. And motor accident claim cases again are a huge area of pendency in most courts. The two states I have been in, Punjab, Haryana and Madras, the single largest category of pending cases, hit motor accidents claim cases. Punjab, Haryana at that time had 45,000 cases in 2014, I remember. Similarly in Tamil Nadu. So why should these thousands of cases be pending, which have easy solutions at hand? Unless it's a fraudulent case, you know you have to give the money. Legal Services Authority plays an important role in this, and once I think the systems are put in place, it will be much better. I always feel we lack in one thing. We don't put systems in place. We're trying to find solutions to only individual based this thing. That may solve a case, but it's not capable of solving all the different category of cases. That's why, Dorothy Thompson said the peace is not absence of conflict, but the presence of creative alternatives for responding to conflict. It is this creativeness for responding to conflicts, I think, which is important. It is my belief that mediation is a critical tool in this process today of people approaching court, and we have to look at it. We are signatory to the 2019 Singapore Convention. We had draft legislation, I think for the first time uniquely created under the aegis of the MCPC, not by some legislative drafting authority, in collaboration with mediators, including international mediators and Indian mediators, sent as an input to the government. That's the maximum role we could have played. Unfortunately, that's also 2 years old. It has gone to Parliament. It went to the Parliament subcommittee. If I may say so, mutilated to a large extent by the subcommittee, changing the focus. Then now another committee has been set up, specialized committee under a formal law secretary to look into it. India will have to meet its obligations some stage, hopefully within this year. If it does so, look at what is going to happen. If there is, as is envisaged, a compulsory pre-litigation mediation, we must have mediators. We must have infrastructure to do this. Otherwise, people will try to abuse the system, and that is the apprehension one, that it should not be that people can't go to court to get urgent reliefs if mediation is a process which is pre-litigation. But countries all over the world do it. They don't face the volumes. So, an upgradation of training and skills in mediators is a very important aspect. We have to take the footprints of mediation much more. Today, just before coming, I inaugurated the program of a TOT, training of trainers, because those have to create more trainers. So, after all, the MCPC is also funding it as part of the Legal Service Authority in some sense. So, it's only another method of doing so. We have so far focused in Lok Adalat as one method, but mediation is another aspect. Similarly, various hybrid solutions today are there. People go to mediation, arbitration, MEDAP, ARBMED. Ideas find a solution. Whatever way I feel, you find a solution. And it's not necessary the best litigating lawyer is the best mediator also. In fact, a very large section of the female gender has worked wonders in the mediation, according to me. Not necessarily only in family mediation. Somehow I find at times a greater empathy and commitment they have helps in sorting out the problem of the litigant. So litigation and mediation require different skills. Let the litigator do his job, but let's get another section of people involved who can help in mediation, as you have people who help in the Legal Service Authority. Some of them may be good defense counsels, some may be interacting, finding solution to the pre-litigation. The paralegals have another role to play. So different people are playing different roles, and it is our job to see the encouragement to them. I want to appreciate the role played by the Legal Service Authority. Much has been done. Much is more to be done. Let's use the statistics to keep on innovating, improving ourselves, and acknowledging what we are doing. Because in public domain, it is necessary that the people know what work we are doing. And that is information to get access to justice. And at the same time, improve ourselves. I would say, let's all interact. We have spoken enough on this panel. The rest of the day belongs to all of you. I would like to listen. So, Justice Khanna, see what you people want to do and carry forward from your ideas. Thank you and Jai Hind.
Thank you very much, sir. Thank you for the keynote address. Now, may I now request Honorable Mr. Justice Pankaj Bhandari, sir, Judge Rajasthan High Court, Jaipur Bench, Jaipur, and Chairman Rajasthan High Court Legal Services Committee, Jaipur, to give vote of thanks.
My Lord, Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairman NALSA. My Lord, Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India and member of an advisory consultative panel of NALSA. My Lord, Honorable Mr. Justice M.M. Srivastava, the Acting Chief Justice, Rajasthan High Court and Patron-in-Chief of RALSA. My brother, Justice Vijay Vishnoi, Judge, Rajasthan High Court and Chairman, Rajasthan High Court Legal Service Committee. Executive Chairman, State Legal Service Authorities, Chairman of High Court Legal Services Committee, and Member Secretaries of NALSA and Member Secretaries of Chhattisgarh, Dadar and Nagar Haveli, Daman and Diu, Goa, Gujarat, Madhya Pradesh, Maharashtra, and Rajasthan. Dear officers, media persons, and other distinguished guests, ladies and gentlemen, I feel honored and privileged to have an opportunity to propose vote of thanks on this memorable occasion. I stand before you with a deep sense of honor, privilege, and humility to express on behalf of Rajasthan State Legal Service Authority our profound gratitude to His Lordship Honorable Mr. Justice Sanjay Kishan Kaul for having taken time off his various responsibilities to join us here today and to share his thoughts with us, and indeed for having inaugurated our West Zone Regional Conference. I heartily thank His Lordship for gracing this conference by his august presence. His Lordship has laid emphasis on the importance of the role played by the Legal Service Authority and touched on crucial aspects germane to access to justice, and with some humorous anecdotes. His Lordship has laid foundation which will serve as an inspiration for ensuring deliberations. Words are not enough to thank his constant guidance and support to shape this conference into a grand success. We assure His Lordship to continue to work tirelessly in this direction for achieving the pious goal enshrined under Article 39A of the Constitution. I extend my gratitude to Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, who blessed us with his gracious presence. His golden words are a lighting beacon which will help us all in nurturing judicial values and achieving our ultimate goal in ensuring justice to all. It is the untiring and continuous great efforts, devotion and support of His Lordship that has brought a great encouragement in legal service institutions. My deep gratitude to His Lordship Honorable Mr. Justice Manindra Mohan Srivastava, who blessed us with his presence and who has obtained the necessary administrative approval for organizing this event. All the efforts of His Lordships have bore fruits through the unparalleled hospitality and generous welcome which all the distinguished guests have received at this conference. I also convey my deep regards and hearty thanks to my brother Justice Vishnoi. I want to express my thanks to each and every participant, but due to shortage of time, because we are already running short by around an hour, I would cut short my welcome address. I extend my thanks to each and every participant. I am also thankful to the District Administration, Police Administration of UDAIPUR, Department of Tourism, Government of Rajasthan, and the management and supporting staff of this hotel. I am thankful to the electronic and print media for the presence and excellent and through coverage of this conference. I once again thank you all for your presence and participation. Jai Hind.
Thank you, sir. Thank you very much, sir. Now, before we close this session, honorable sirs, ladies and gentlemen, dignitaries, I wish to inform you that this is a time for our national anthem. As a mark of respect for it, I gather the courage to request you all to arise. Thank you.
सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे जन गण मन अधिना.
Please be seated. May I now request you to proceed for a group photograph outside the lobby area, followed by high tea at Amrit Mahal. After that, we gather here for our next round of sessions that will begin at